Call to order. They will rise for the invocation and the pledge of allegiance. Heavenly Father, as I come today, Lord, I want to thank you for your blessings that you have poured upon us. Lord, thank you for our community coming together and coming out. Lord, thank you for letting us see another day. And Lord, as we go into this agenda, Lord, please open our hearts and minds and spiritual eyes and let us make good decisions. As I pray in Jesus' name, amen.
Amen.
I pray
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, roll call. Councilman Robert Gansby.
Present.
Vice Mayor Nicole Williams.
Present.
Councilwoman Shirley McCall. Present. Councilwoman Shirley Aldrich.
On the phone, yes, ma'am.
And Mayor Brown is here. Okay, the next thing on the agenda is additional deletion and amendments. Do we have anything to add to the agenda? Or anything to delete? Next item on the floor, next thing on the agenda is citizens from the floor. 5 minutes, please.
Were you for the regular council meeting or the planning and zoning? Yes, yes,
This
ma'am.
is the council meeting. The planning and zoning meeting will follow that.
So anybody have anything to say at this town council meeting? Okay, let's move on. New business. A, resolution 25-13, appointing land development regulations administrator and administrative authority. Pages 3 and 4.
Read it by. A resolution of the town council of the town of White Springs, Florida, designating the town manager as the town's land development regulations administrator and the administrative authority, providing conflict, severability, and an effective date.
Okay. Do we need to make a motion? Adopt it.
I move that we adopt Resolution 2513, appointing land development regulation administrator and administrative authority.
I second the motion.
Okay, it has been moved and seconded that we adopt resolution 25-13. Any discussion? Yes,
This basically states that the town manager will be this person?
yes. Any more discussion?
So our LDRs define the land development regulation administrator as the person assigned by the council to the role of land development regulation administrator. So what this resolution does is we formally appoint, in this case Lee, as our land development regulation administrator.
So he's in charge of interpreting LDRs for us?
He's the chairman of the committee, is what this is doing. It's establishing the committee and appointing him as the chairperson of the committee.
No.
So this assigns anything in our LDRs that are the responsibility of either the office of the land development regulation administrator or directly of the land development regulation administrator to Lee.
So what will his duties be as this person?
Site planning, permitting.
And will he have?
There's like 240 references in our LDR.
And will he have to give input to us, or will he just do what needs to be done?
For the most, so if it's something that he can do that doesn't require the town council, he can do it on his own.
Most of the things are already been pre-approved, probably, that I will be looking at, but if there's anything that, questionable, I should have come to you all and the attorney for advice.
Any more discussion? All in favor?
Aye.
Any opposed? Ayes have it, motion carried. We got you, Shirley.
Thank you.
The next one is, resolution 25-14, appointing of local planning agency and planning and zoning.
Read the preamble. Town of White Springs, Florida, Town Council Resolution number 2025-14. A resolution of the Town Council of the Town of White Springs, Florida, designated itself as a local planning agency pursuant to section 16.31741 in parentheses, Florida statute, and designated members of the Town Council to perform the functions of the Planning and Zoning Board pursuant to Article 3 of the Land Development Regulations as amended, providing for school board representation, establishing duties, providing for conflicts, severability, and an effective date.
Council, what's your pleasure?
I move that we accept resolution 2025-14, designating the town council as the planning and zoning agency.
I second the motion.
Okay, it has been moved and second that we, approve resolution 25-14. All in favor?
Aye.
Any discussion?
Oh, wait.
I'm sorry, any discussion further?
Are we gonna be working with the comprehensive committee too, to understand what questions we're gonna be answering, or?
No. So the comprehensive plan committee exists right now to bring our comprehensive plan into alignment with the requirements of the state. That is kind of a subsection of what the planning agency does, which we'll be assigning ourselves as a local planning agency. As far as stuff like this, small-scale amendments to the comprehensive plan, citizen-initiated amendments to the comprehensive plan, that has nothing to do with the comprehensive plan committee.
What we're doing tonight has nothing to do with comprehensive plan?
No, nothing to do with the committee. So what we're doing tonight has nothing to do with the operations of the comprehensive plan committee. That exists specifically just for getting the comprehensive plan into alignment with the process established by the state.
Okay,
And to
so
make amendments to the
if
comprehensive.
we all become planning and zoning committee, are we supposed to understand the LDRs?
So for this exercise, we're only supposed to consider the evidence that's presented to us.
No, I don't mean the hearing tonight, I mean this committee, this thing that we're voting that we're gonna do. What are we gonna do?
So like, are we going to be the permanent zoning board? Is that what you're asking?
What will we be responsible for doing if this makes us that committee? Tonight? In general?
So I think she's asking, are we basically conferring permanently all the powers of the zoning board to ourselves? Like, I know we're doing the
I
invoice.
wanna know what my responsibilities are gonna be if we vote this in, as a council person. I don't just say, oh yeah, I'll do that, well, yeah, I do that, I mean, in this sense.
It's very relatable, Cheryl.
Ensuring that the things that are brought through you for action have been reviewed with you by planners or engineers, whatever that we have to do, and that before we bring something to you, at least you have been briefed on it. And that's the reason I'm saying, maybe workshop throughout, have workshops and bring to you something that's gonna come before you at a future council meeting. So you've had time to look at it, deliberate it, ask questions, and get response.
Like this, that we're forming tonight is gonna be over what we're doing later at the hearing?
You're designating yourself as the local planning agency and the planning and zoning board. The planning and zoning board will then meet after this meeting to hear to do the public hearings on the 3 applications.
So we've got a lot of responsibility at this point.
That's for, this could be a temporary designation, this may not be a permanent designation.
Okay?
That's something that you guys can determine long-term, but for purposes of what we need to accomplish today and in 2 weeks, the council is designating itself as the planning and zoning board.
So what's the difference between today and 2 weeks?
Today, the planning and zoning board hears the applications, and in 2 weeks, the town council hears the applications. Today, the planning and zoning board makes recommendations,
To ourselves?
yes, and then in 2 weeks, you make the determination. The land development regulations allow for the town council to designate itself as the planning and zoning board.
So after today's hearings, and I'm sorry, that are just, this to me is a lot of responsibility, and I want to get it straight. So what we're going to do tonight is we're going to hear everything. Are we going to make any decisions on anything, or are we just going to advise ourselves next week on what we heard tonight?
You're going to make recommendation at the end of each hearing. And then in 2 weeks, will be another public hearing where people can still come before you. It may be new information, it may be different information, it may be information that doesn't necessarily support the last decision. So it'll be, these are 2 hearings. You're sitting and you're doing both, but you're doing them with different hats on and different responsibilities.
Okay.
Today, recommendation, 2 weeks, decision.
Gotcha, thank you. Sorry.
That's okay.
Any more discussion? All in favor?
Aye.
Aye.
Any opposers? The motion carried, ayes have it. Okay, the next one on the list. Oh, see, resolution 25-15, waiving requirements of resolutions 07-13 for RZ 2025-01, RZ 2025-02, and RZ 2025-03, pages 7 through 11.
So, up until approximately Thursday, we were not aware that the town had a schedule of fees to charge for applications, such as the applications that we have before us today. That was the first time that we had heard that they existed, and then we didn't see them, I didn't see them until Friday. They are from 2007, Resolution 07-13, and part of the resolution states, until the following applicable fees and charges have been paid in full, no action of any type or kind shall be taken on a petition, appeal, or application. This information was discovered weeks after the applications were submitted, in many cases, months after the applicants have been trying to get this done, and essentially 1 business day before the actual hearing. So in order to hear these applications, the town council needs to consider what to do about that resolution, and an option has been drafted, Resolution 2025-15, which would allow the town council to waive the requirements, fees, and charges adopted in Resolution 0713 for these 3 applications, and limiting that waiver only to these 3 applications. But the town council has to decide what to do in order for us to be in compliance. Let's see here. The land development regulations state reasonable fees sufficient to cover the cost of administration, inspection, publication of notice, and similar matters may be charged to applicants for zoning amendments. The amount of the fees charged shall be established by resolution of the town council filed in the office of the town clerk. This resolution, the schedule of fees, was also supposed to be posted in the town clerk's office. It was not posted in the town clerk's office. So here we are.
Can it be a third designation? Oh,
Chair. Ma'am.
Go ahead. Oh, I'm sorry. It's not in my eye.
I forgot. Can there be a third option in that we postpone these until we can handle them since the election's not, the final hearing's not for another 2 weeks? Rather than just say, do away with it because there are we do have a good amount of costs. It's just the reason towns have fees, but we want to be fair. We don't want to make these people wait another forever and ever amen. Can that be an option that we postpone with the fees or something?
Any option is on the table, that's for you to decide. But the town has already paid for publication for these hearings to be heard on the 14th and the 28th. And if the hearings are not heard on the 14th and the 28th, then the town is going to still have to incur fees. So the fees that we've already spent, we're not going to get recouped anyway, because now we have double expense because we have to start the process.
Well, I'm not saying put off the hearings. I'm saying put off the decision on how much the fees would be, because this is a normal process, is it not? It's not something that just popped up out of the blue. It did for us, but everything does for us. So if this is a normal point of business for a town to have fees, would we be remiss in postponing it till we figure out, are these fair fees for what they were done, and don't make it contingent on before, they have to pay for it before the hearing?
That's up for all of you to decide.
I'm just trying to spare the town when this is not an abnormal plan of business or whatever. I don't know what I'm saying.
This is just for these three applications, it's not for interest. It's just
That's
waiving the
understood,
fees.
but we are paying all this money to accommodate them.
We did the same thing with the Diamond Flats last week, we voted to waive everything.
Why? We did? We voted to waive their fees?
Didn't we waive something for them last week? Well, we didn't, but no, what we did was to not make them, we made it where they wouldn't have to hook up to the city,
Well,
which is
that's still,
technically waiving a fee for them.
that's
Oh,
still.
let's just waive the fees for everybody. Always, forever, and ever. This is.
Is this, now,
Yes, go ahead.
are these considered actions, where you get, if you don't act within a certain time, of actions that have been done, completed, throwing somebody and is this, I think the same state statute covers rezoning, it's got to be done in a timely manner. And I know some of these have been pending a lot of time.
The town is obligated to hear these matters in a timely manner, and we have certainly pushed that to the limit already. We've tried, once we became aware of the situation, to try to get these scheduled as quickly as possible. But if for some reason they're not heard today, we've got to start.
I'm not saying put off the hearings. I'm saying put off the choice of whether or not we have fees that are applicable, because we are incurring expenses that are normally covered by fees by every town.
I think it would just be a matter of how you articulate that, what it would look like.
So the most fees that we've had to incur is just advertising,
No.
or what?
Well, that's the one we know about, that's a hard cost. There's obviously attorney time and planning consultant time. But it's also hard to
But
give it a number because this is our first time doing it. So we're doing everything from scratch, which takes far longer.
All right, let me ask you a question.
Sure.
With the amount of time that you had to put in, your the most of your fees came from the letter, because you got the letter from the attorney, which made it a legal matter, correct?
Correct.
Okay, that's all I want to know. So that's the letter of our fees, which means it still wouldn't be on the citizens, it's still on the town, because the letter went to the town and it wasn't the citizens, correct? Oh, that fee be something that the citizens would have to pay, your legal fees? Or is that the town, because you were given the letter from a citizen's attorney?
I work for the town, so the town
So it's for the town,
pays it.
so it's not a fee that the citizens in question with the 3 parcels would have to pay. Yeah.
And if I may say one other thing, public, back in 2007, just what we're talking about tonight was a fee of $1,000, which is exorbitant in any place I've ever been.
It's what?
$1,000 to amend the official zoning letters. Less than 10 acres.
Understand that's high or low?
It's high.
For 20 years ago,
Well,
you're seeing fees like that more,
Oh, no, no.
not around today.
no.
But everybody's different, everybody's got different fees. When the town creates their fees, they need to do a lot of research into figuring out what's a fair amount.
Well, but that's sort of leave, but not tonight. What I'm asking is that we've postponed this fee thing, don't just throw it in the trash. And go ahead and do the hearing with the option to bring this back up. Is that something doable?
So let me see if I can articulate it for you. That this would waive the requirements and fees and charges outlined in the resolution to the extent that it would allow the applications to continue to be heard today. And the town council can meet at a later date to determine if any fees will be charged for these applications? Is that what you're suggesting?
I'm thinking so, because it's not an odd occurrence. It's not a out of the realm thing to have fees for what we're doing. Am I correct? So why would it be totally just thrown in the trash if there's another option?
That would be up to,
Robert?
Up to me?
No, I just want your opinion.
I
You don't get
very,
the total vote.
I get 6 votes, sorry. I very rarely find myself stumped when it comes to something like this. And I honestly, every option feels like a bad option. Because we have incurred, I don't know, I can't even put a number on it, but it's significantly more than $1,000 of expenses per request. I know that we can't be setting a precedent to not charge fees, but at the same point in time, it's not the applicant's fault that they've had to wait 6+ months to get their applications heard. And it feels like either way, you either have to redo the notifications, right? We have to spend another $400 on putting it into the newspaper. This meeting here probably is costing us $1,000 to put together. So that'll all have to be kicked down the line again, but at the same point in time, if we don't charge fees, we open ourselves to an appeal saying we didn't follow the process. If we don't follow the process, it could all just end up being squashed on appeal anyway. We're back to square one. Nobody wants the state showing up to their house in 6 months and tearing down the trailer because we didn't make them pay a fee for this. So it just feels like either way, we're gonna make the wrong decision.
Is
So
this
that's why I'm
something-
sitting here quiet.
Is it something you can make from the people like we did before, on spending their money?
We can definitely get their opinions on it, but there's risk regardless of what we pick. And as far as deciding to move forward without fees or knowing the fees, in 07-13, it expressly says that you're not allowed to work on it until you get the fees. So we'll be off process again if we sell them, we can come back later.
Unless we do the resolution, right?
The process is what the council decides the process is. The fees are what the council decides the fees are.
So if we can make specific fees for this occasion, that would satisfy that.
Yes. Because none of this schedule of fees were ever posted and made available. So it's not the applicant's fault.
It's not the town, well, it's the other town.
This is 2007, it's the town.
So can I ask, yes, more or not?
So,
I would love to hear from the people, see the face.
Hold on one second. Wait a minute. Shirley, do you have anything to say about this?
I think I'm following what Cheryl is saying as far as, are we gonna waiver this fee for everybody else that decides they wanna move in with the
No.
home?
It's
And
these three.
why-
Just these three.
Just these. And it's simply because it wasn't posted before?
It wasn't posted, it wasn't known about. No one currently affiliated with the town knew it existed until Thursday. And the resolution also states that any application submitted after the effective date of this resolution must comply with the requirements of Resolution 0713 or any subsequent resolution enacted to establish such requirements.
Right, okay. Okay. I understand what you're saying, I mean, it's just, I am on medication right now, so I do understand what you're saying. I was thinking that Cheryl was trying to think also that if we waiver this, then what right do we have to not waiver it for someone else? Cheryl, am I hearing you right, or
Well, I think if it's worded right, it'll just be specific to these three.
just these three specifics? Okay, okay,
Because of these special circumstances.
okay, I understand, right, okay.
However, it's responsibility to the citizens to spend their money, I think we should hear from the citizens. All right, guys, somebody say something.
Wait a minute.
Wait.
Hold on.
No.
Let me read the resolution by title. A resolution of the Town Council of the Town of White Springs, Florida, waiving the requirements, fees, and charges adopted in Resolution 207-13 for applications RZ 2025-01, RZ 2025-02, and RZ 2025-03, limiting said waiver to only these applications and providing an effective date.
Okay.
And that's the number assigned to these three. We're going
Is the floor open? Yes, I definitely can say anybody from the floor want to speak. Let me talk.
Good afternoon, good evening. I'm Roger Green. My address is 16590 Spring Street, White Springs, Florida. It's nice that we're going to have a land development zoning board now, but I can tell you, if you don't have a fee schedule, you're going to be inundated with amendment changes. You set this fee schedule low, you're going to spend all your time dealing with amendment changes. I mean, our tax base in this town is based on our, is somewhat based on this fee schedule. And we have very few people paying in. Growth is coming this way. There's going to be a lot of people, a lot of things that are going to come up. They're going to request amendments to land development regulations. And if you need to set that fee at a point where it's worth their while, it's got to be really worth their while to amend those land development regulations. What we have parallels the city of Gainesville, Florida. They've been in tax since 1998. We've gone a number of years without our council being even aware of land development regulations, and they completely ignore them. So we have to have a fee schedule, and I would advise you to ask the applicants right now. You know, if you throw out a number, if they're not willing to pay $1,000 for their application, they may want to withdraw, save a lot of time in even presenting the application. That's all I will say.
Thank you. Anybody else?
Scott Gay, 10565 Kendrick Street. The town didn't just restart with the change of the administration. These rules have been in existence since 1998. The dollar store followed them, Dollar Store 2 followed them, the liquor store followed them. We just don't get to restart 3 months ago. But I think by suggesting that you set a special fee schedule, you're creating a second class of applicant. So we have two classes of applicant now. The ones today, because of special circumstances, anyone who follows. So, but the town just didn't restart 2 weeks ago. You stepped in the shoes of an incompetent administration. So you have to deal with the issues they created. You don't get to sweep them under the rug. We have to pay the price. There's a price for doing things wrong. There's two sides to every transaction. So that's all I would say on that.
I thought it would work, Steve.
Judith McClure, 16630 Spring Street. In regard to Resolution R, I think it's 2202503, I do not wish to see the zoning change to permit this trailer for several reasons. One,
Hold on.
We're not talking about that.
Not yet.
We're not
We are talking about fees right now.
fees, okay, I
Yes.
apologize.
Yeah, the fees right
I
now.
will be back. I
Okay,
have 2 pages.
okay. We talking about the fees, nothing else but the fees.
I know. I'm Sunitha Williams, 16974 Sunrise Drive, White Springs, Florida. I am one of the applicants. I do not have a problem with the fee. If there's a fee set, I'm willing to pay it. That's all I have to say.
Okay, both of them are willing to pay $1,000 fee.
Now, would that be 2,000 for us since it's 2?
Wage each one, yeah.
By when?
But I do have a question, Cynthia. When you were working with the town, and this goes back to the diamond plat that just got approved, when they filed to get theirs rezoned last year, did they pay the $1,000 fee for the rezone?
No.
So, I'm just gonna put it like this. It wasn't an issue about that. None of you complained about them not paying their rezoning fee. Nothing came up in those meetings about the fee when they applied to get rezoned. And this is a multi-million-dollar company who applied for the rezoning. This resolution is only for 3 properties of people who live here in the Sound. You did not make a development company. None of you questioned it. When the development company wanted to come get rezoned, nobody questioned their fee table, what they had to pay. And they, looking at this list, they would have had to pay quite a bit more fees than just $1,000 for the rezoning. I don't see what the issue is. Some of these things I'm starting to look at as maybe personal with some people because Diamond Plats didn't pay it. And that's North, I'm talking, you can talk in a minute. Wait a minute.
North Florida Planning and BBL, those are million, those $2 million, those are companies that make well over $1 million. Are we gonna go back and charge them a fee now? Is that what you all are suggesting?
Yes, there's
Okay.
your oversight.
As long as it's the same for everybody else, because they've already been approved, so how do you suggest we're gonna go back and do that? Because they've been approved.
Talk to your county attorney.
Because that never came up at all with them, period.
So we absolutely cannot use the way the previous administration operated in zoning for any kind of standard. They ignored the 4 rezoning requests for over there for 3 years until the developer lost their funding, their investors walked away because they got tired of waiting, and they lost everything in that deal. So you're talking about people who lost 6 figures of money because the town sat around and did nothing for 3 years. So I'm not sure what exactly we're going to glean from how they did anything.
What I'm saying is, when they applied, the same people that come to these meetings now are most of the same people who were at these meetings previously. We have the same group that's at every council meeting. No one mentioned this fee schedule then. This is not a permanent thing. It's not like we're sweeping anything under the rug, even though both said that they can't afford it and they will pay it, which is no problem. They've already agreed to do it. It's just that I'm asking the question, why this has never come up before with the previous properties that have been rezoned. They didn't pay the fees either.
They didn't know anything about these fees?
No, and we just found out about them after they have applied for them and been waiting to do them. So when you're saying be fair, be fair. If they want to pay it, okay, then there's no problem for them because they all can afford it.
Well, can
So-
I say something about
But
that?
it's just,
Wait a minute.
I would obviously rather not have to pay $2,000 on something that I previously wasn't aware that there was any fee on. If it has to be done, it has to be done. But part of this is, what we're rezoning is 2 properties together. So if I get doubled on the fees, that's a little more painful to me. And I think that you'll see in my presentation, that this was originally most likely a mistake by the city to begin with.
I think I made a mistake, because it says the $1,000 is up to 10 acres. We've got less than 10 acres in this too, right? So I think it'd be up to 10 acres, I think, it says in the official zoning atlas, less than 10 acres, and so I think that would be $1,000.
Are we at the 1,500, Robert? Is it
Are
1,500
we
or
amending the
1,000?
No, we're amending the zoning atlas.
Less than $1,000, the official zoning
$1,000,
atlas.
Mr. Hudson, $1,000.
Yeah,
Gordon, according to this.
yeah, $1,000.
For some reason, it's the
So-
same price.
So if it's less than 10 acres, they don't have to pay
They
the
pay
$1,000?
$1,000. They pay $1,000.
They pay $1,000?
Up to 10 acres.
Up to 10 acres.
So,
That's
oh, I'm sorry.
more.
Oh,
So, George Tudor, 16511 Jewett Street, White Springs. So each parcel is its own separate transaction. So if I have several vehicles that I take to the county, even though I live in one spot, I pay registration for each one of those vehicles. So if I'm coming forward to the town with multiple properties to have a zoning change, then there's a process for each one of those properties that the town has to go through. So if each tract was over 10 acres, then that would be a different thing. But if the fee is for up to a certain size, then that fee applies to each property that they want the zoning changed on.
yes, sir.
Good evening, Tom Brazil, property owner at 16504 Collins Street. First off, I want to say, y'all are doing a job that nobody would want.
Yeah.
Y'all inherited a dumpster fire, okay? I disagree with Scott. You're not if you waive the fees, you're not creating 2 classes, you're creating 3. You're creating people 4. You could see the thing for the fees now and for the thing for the future. You're creating 3 classes of people. The zoning problems in the town are not your fault. This stuff's been going on for a long time. But we got to start somewhere to fix things. And you're either going to have a fee schedule or you're not going to have a fee schedule. You know, you start waiving it for this one, then, you know, we get somebody else on council and they got somebody they know and they want to waive it for that person. You're opening, an attorney probably tell you, you're opening a trick bag doing it. I really think you need to just, if there's fees involved, there's fees involved. Whether they've had to wait 2 years or whatever, I agree. You know, if they want to recoup some of their costs, they can litigate with the town. But, you know, you can't fix what the previous council did. You can't fix the fact they waited 3 years on some of these zoning applications. Diamond Acres over there, we can't fix that, that's already done. Now, you may want to, if the attorney can tell you to do it, rebill them for fees. If that was what's required in the zoning change, I don't know if you can or not after the fact, but like I said, I just think it's a bad precedent. We got to start somewhere to fix this. Because you got so many zoning, you've got a property zoned as a school that people are living in. There's so many zoning problems in the town. But we got to start somewhere to fix it.
Anybody else?
Yes.
Scott Gay, 10565 Kendrick Street. Nikki, the difference between now and Diamond Street is that was run in secret and there was no sunshine. Thanks to you guys, we're doing things in the sunshine. Most of us didn't know what was going on with Diamond Street. Diamond Street should not be signed off on now because there was some false information submitted. That's why they got the permit. So if that's been signed off on, that's a problem. But thanks to the sunshine, we now know about it. We didn't know about the BBL stuff, a lot of it.
And just for information, it has not been signed off, although the law says we need to. But I'm having our engineer review everything on there before we go further.
That's all you can do, just get the engineer to review it.
Anybody else? Council, if y'all have anything to discuss?
Come up with a rewording on this resolution.
So, you want me to use my deductive reasoning of what you are trying to vibe over to me? Okay. Let's see here. So, section 4, applications 1 through 3 can be heard at the public hearing set forth, and all further action necessary to complete and continue without delay. We can keep that. Okay, we all agree on that, right? All right. Section 2, about waiving the requirements and fees, we can remove that language, okay? And then looking at section 3, that is where we can state what the fees and charges will be for each application, but also when would they be due. And then in section 5, we wouldn't call it a waiver, we would call it something along the lines of these provisions. Is that kind of meet what you're saying? Okay. And then, go ahead.
In fairness to the applicants, if they would make known maybe to you what would be a good time frame.
Within a reasonable time period?
Yeah, I think so. That would be fair to them and fair to the town.
So we call it, if you're willing to pay the fee.
Are we gonna charge them the entire 1,000 or are we gonna?
That is a discount. This is costing us easily between $2,000 and $3,000 an application. They're getting a steal at 1,000. So that's my opinion on that.
Since the questions come up, the way this is written about less than 10 acres, I think, from what I've been around, I think it's one zoning, although it's 2 applications here. So it may be $1,000, but I'm sure like to ask if you would, maybe get what the.
For the first 2,
For the
to
first
combine
2.
them into one?
Yeah. I think if we combine them as one, would y'all be objectionable to changing the parcel number to one parcel?
Well,
Should-
yeah.
Only up there in green.
You have some homes on it?
Huh?
No. I don't know about changing the parcel number.
Well, I mean, I don't know,
Yeah.
I know you can subdivide that and.
This
That
year,
way creating a
More
problem.
properties, one property gonna pay just as much as the 2 larger.
I think for the sake of this hearing, that's how we word it, that these 2 applications are considered as one.
The changes, the requested changes are the same and the arguments are the same. And I would presume with the planning consultant, the evaluation was the same. There's one memo for
Even though
both.
we have to file 2 applications, blah, blah.
If we're gonna pay, if we're gonna do it the correct way, not trying to be, but to make it fair, because he has 2 properties he's getting zoned. It's not fair to Saniti to have to pay $1,000 for 1 property, and he's only paying $1,000 for 2. So if we're gonna follow the book, let's follow the book,
And Diamond also will only pay $1,000.
which that means they need to pay 3 now, correct? Because they have 3.
Yeah, whatever the
Okay.
license, yeah.
So how the other, if we're gonna follow it, we're gonna follow it and do the same for every person. No special, if we're gonna do whatever we're gonna do it across the board for everybody to keep it fair and above board.
Therefore,
Yeah. Correct.
Okay, and then time period wise, do we want to maybe hear from them so that it doesn't have to be, I don't want it to be just me. I want it to be in the resolution about time wise. From there,
In the next 60 days, maybe?
60 days? Okay. All right, so we've got section 1 would stay the same, section 2 is removed.
Okay.
Section 3 will state that within 60 days, a $1,000 fee will be paid for each application. I'll put out which ones they are, 1, 2, and 3. And then number 4 becomes 3. Applications 1, 2, 3 can be heard at a public hearing set forth for July 14th, 28th, and all further action necessary to complete the application process may continue without delay. Section 5 becomes 4. These provisions only apply to these 3 applications. Applications submitted after the effective date of this resolution must comply with the requirements of Resolution 07-13 or any subsequent resolution enacted to establish such requirements, fees, and charges. And Section 5, this resolution shall take effect immediately upon adoption.
Don't we need to waive Article 1 of Resolution 07-13?
Number 3 is to now can be heard, let's see. We can add in, if you'd like, I can add in. Let's see here, the provision that states that the provision stating until the following applicable fees and charges have been paid in full, no action of any type or kind shall be taken on a petition, appeal, or application shall be waived. Is that true?
Otherwise, we'll have to adjourn.
Okay.
We change the third way around?
Yeah, so we can make that one the new 2 and then go back to the original numbers.
All right, say that again.
All right. Okay, so section 2 will be,
The third,
Here,
okay,
over here.
make my notes.
this will be two.
So the requirement stating that until the following applicable fees and charges have been paid in full, no action of any type or kind shall be taken on a petition, appeal, or application shall be waived. Within 60 days, a $1,000 fee will be paid for each application. Applications 1, 2, and 3. 4 remains the same. 5 just states that these provisions only apply to these, and then the rest of the department. That's the only change. These provisions are going to apply.
Shirley, you have anything to say at this time?
No, ma'am.
So we need a new motion?
Motion second. As amended.
Okay.
As amended,
As amended.
with the stated amendments.
That was Shirley's motion. Golly.
Okay.
With the
Let's make
stated
sure I got
with the
this
stated
correct.
amendments.
I think we have a motion there.
No.
No, you don't.
Oh,
No, we just gotta make a motion. Okay.
Motion to approve. As amended.
Okay.
No, the stated amendment.
I move that we accept motion 2025 with the,
Resolution.
resolution 2025 with the approved amendments for resolution 713 for the rezoning of 2025-01, resolution 2025-01, resolution 2025-02, and resolution 2025-03.
One correction, sorry. For the title, instead of where it says waiving the requirements, let's call that amending.
Amended.
And that said amendments.
okay, amending requirements.
Amending the requirements. And then later on, that said amendments.
I second the, motion.
Okay, it has been motion and second that we amending requirements, resolutions, 07-13 for, RZ 2025-01, RZ 2025-02, and RZ 2025-03. Any discussion? All in favor? Aye. Any opposed? None. Amendment?
No?
Oh, that's it.
That's it?
That's it. That's it.
Oh,
We're not doing all that.
So I may make one statement as well. I will get with Florida League of Cities and get a synopsis of all the small cities in the general area of, what the fee schedule is, so we'll have something to work with.
okay.
And if we make any changes or add anything to it.
Madam Mayor, I move that we adjourn this town council meeting.
I second the motion.
There have been motion and second that we adjourn this town council meeting,
You gotta call the time. 6:55.
6:55.